And then
system. They really, really don't like to write a letter saying that their patient is unable to manage their affairs. They try to avoid doing that. They try to send you to a different specialist to get expensive tests or expensive neuropsychiatric evaluation because they don't want to write that letter. And the reality is that families know when a power of attorney has to be activated, or the principal, the person who's giving power of attorney, may simply want to delegate. I took over handling my mom's affairs when she was about 85. She was perfectly mentally capable of doing it all herself, but she had lost her vision. And she just plain got tired of trying to, figure out, hold the bills under her special reading machine that enlarged everything 3,000,000%. She just said, I don't want to do this anymore. And so a doctor might not have even written a letter saying that she was incapacitated, but she wanted to delegate, and she did. And so we recommend that as being the best option for everybody, to have the document be effective immediately. That brings up the topic, and it's a really important topic, of who do you pick for those roles? And you may hear the word fiduciary, because fiduciary is kind of an umbrella term for a number of different roles. A fiduciary would include the executor, also called the personal representative of your will. It would include the trustee of a trust. It would include your agent under a durable power of attorney, sometimes also called the attorney in fact, as opposed to an attorney at law, the attorney in fact, or the agent. And these are all really important roles. And why they're all called fiduciaries is because they are roles that are all bound by something called fiduciary duty. And fiduciary duty is a duty of utmost loyalty. So the person who is serving in that role has to act in your best interests, not in their best interests, if there's any conflict there. They have to make the decision that they believe that you would have made if you could understand all of the circumstances. And they have to avoid any self-dealing or benefit from the relationship. So it's an important role, and given that duty, you have to select someone that has the right skill set for the job. So this isn't something that is a gift that you have to provide in birth order. Your eldest child might not have the right skill set or personality to do this. You might choose the family member who lives closest to you, although that's not necessary. In this day and age, with all of our communication that we're developing, it's perfectly okay for an executor or an agent under a power of attorney to live in another state or even another country. I just was working this week with a daughter who's an agent under a power of attorney, and she happens to live in London. And you have to take the time difference into account, but it works just fine, and it's very doable. We're able to communicate all over the world at this point. So you have to pick the right person for the job and not worry about hurting someone's feelings. You're the employer and you're doing a job interview, and if your eldest son is a bully who is not going to follow your wishes, or has a gambling problem and is not going to be able to resist temptation to dip into your money, then don't worry about hurting his feelings. That's not the right person for the job, and you need to pick someone who is. One of the questions I got in advance, and this is a common question when I talk especially to older audiences, folks whose children are grown. What do you do if you don't have a family member who's the right person to choose? Many people don't have a spouse or children, or many have spouses or children that they don't want or trust in that role. And this is something that comes up a lot. And really the best solution for that is to work with a professional. Unless you have a close family friend that is willing and able to step into that role, there are professional fiduciaries who charge very reasonable rates. A lot of people think about in the past, their documents or their parents' documents named a bank or a trust company. And I think that that was more common in the past. But these days, today, the banks and the trust companies will fulfill that role for very high net worth clients. So they're really not going to be interested in stepping into that role unless you have usually more than about $2 million. And then they work on a percentage of the assets that they have invested for you. So that's not a good fit for the vast majority of my clients that I work with. They don't have that kind of money. So there are other organizations, and you can go online and search for professional fiduciary companies. And these are folks that work on an hourly fee for service basis. So you get charged for what they do for you. So if all they're doing is being named as a backup or an alternate, they're not going to charge you anything. They sometimes charge for an initial meet and greet 1 hour, to get to know who you are. But if they're not doing anything for you, but are just named in your documents, there's no charge. If they do take over managing your affairs, then they're going to charge you for what they do. So if they're paying your bills, if they're cleaning out and selling a house for you, if they're attending medical appointments and making medical decisions, they're going to charge you for what they do. But this usually is the right option for folks who either have no family members who are suitable to serve, or they don't want their family members in that position. Another role, and we're going to get to this towards the end of my talk, is you can designate the person that will make memorial instructions for you. And that's a handy thing to do. A lot of people don't think about that because it doesn't really fit in the will. It doesn't really fit in the power of attorney, but it can be very helpful to your family, especially if you have 6 kids and you haven't designated one person to make those memorial instructions, then the poor funeral home is going to have to track down signatures from all 6 of your kids. And that's kind of a big hassle. And so you can, under Washington law, you can simply designate so-and-so is my designated agent for funeral arrangements, and so-and-so is the backup, and so-and-so is the second backup. So you've named one person that can take care of that and will know your wishes about that. One question, and I'm leaving powers of attorney and kind of going back to wills for a second. A question that I get really, really frequently from a lot of audiences is wanting to know the difference between a will and a revocable living trust, and whether you need a revocable living trust if you own property in the state of Washington. And the short answer to that is that one of the primary purposes of a revocable living trust, and what a revocable living trust is it's a document that is a contract to manage your assets. And so if you think about it, it's kind of like creating a container that you put assets into, and you name the person or the series of people who are going to control what assets you put in that container. So sometimes people are not given complete information. They create a trust, but then they don't put anything in it. So the trustee, who's the manager, doesn't actually have anything to control. But the primary purpose of creating a revocable living trust really is to avoid probate. And probate is a scary word. It simply means the process by which an estate is managed after death and your assets are distributed. And we're really, really lucky to be in Washington. because Washington has one of the most simple and straightforward and inexpensive probate processes of any of the states. If you live in certain states like California or Arizona or Florida, those states have probate processes that are expensive, take a really long time, and you end up paying a lot of money to go through probate. So people take extra care to plan to not go through probate. Because in Washington, it's not that big a deal to go through probate. For the most part, we don't recommend that you spend a lot of money and hassle creating this container for your assets and putting all of your assets in it and designating a trustee for those assets if what you're trying to avoid isn't that big a deal. So for the vast majority of our clients, we say that having a will is just fine, and you can tell Susie Orman to go jump in a lake because Susie Orman lives in California and she doesn't necessarily understand that other states are different from California. So I know that she says everyone needs to have a trust, but take it in context that she lives in California. Now, we meet a lot of people who are from California and have had a trust and have had all of their assets in a trust and it's working just fine for them. And we can help them update it, make small amendments, and there's no reason to get rid of it because it's perfectly fine. It's working for them. They've already spent the money and the effort to create it and to fund it. But for the most part, if you're starting fresh, the vast majority of our clients, we do wills to deal with the assets after death rather than a trust. So I need to figure out where my clock on my computer is so that I don't run over. Okay, now I've got a clock in front of me. That's good. Okay. One of the questions I got in advance, and this is a really important one, and I think this is a topic that elder law attorneys really, really think about when we meet with you and help you with your estate planning documents is, how do I avoid conflict? How do I avoid my family fighting over what I want to do? And how do I make sure that they're not going to fight after my death? And the idea of a will contest is very, very scary. And the idea that somehow your wishes aren't going to get carried out is very, very scary. And so we like to find out from people what they know about their family and who's likely to make a fuss. And it's really important. I think these are the situations where it's really, really important to work with an attorney, because an attorney can make sure that your documents are as bulletproof as it's possible to make them. And so the first thing to do is, as we discussed before, choose the right personal representative for your estate. Choose the right person who's going to be in charge of figuring out what all of your assets are, gathering them up, figuring out what debts you owe, paying the debts, and then distributing your assets according to your wish. So you want to pick the person who's good at obeying rules, good at taking instruction, because an attorney will instruct that person how to do it. They don't have to know coming in. I've never done a probate. How do I do a probate? The attorney will tell the personal representative how to do it and what to do. But you need to have somebody who will follow instructions and not go off the rails and be trustworthy that the money in your estate is just under their temporary care and does not belong to them, and that they will distribute it according to your wishes. So choosing the right personal representative is really important. The next thing is to be completely clear and unambiguous in what you put in your will. One area that is often ambiguous is about loans and gifts. So if you gave your daughter $100,000 to use as a down payment on her house, and it was unclear whether you expected that to be paid back or whether it was a gift, that needs to be spelled out in writing. Maybe you called it a loan at the time. I made a loan to my daughter in the amount of $100,000. that loan is forgiven at my death, or that was a loan and will be considered an advance against her inheritance. So you have to be really clear so that the other family members can't fight and say, well, you didn't say whether that was a loan or a gift. So that's important. Stuff is something that people often fight about, and you can be very clear about your stuff. It's, in legal terms, it's called tangible personal property. But stuff means cars, boats, artwork, jewelry, furnishings, mementos, photo albums, all of that. And so if you know that your family is going to fight over the stuff, you can create an attachment to your will called a tangible personal property list. And what's really cool about this list is it doesn't need to have two witnesses like your will does. It only needs to be dated and signed. So you can do that on your own, and you can update it every month if you want to. If you decide that one month your grandson gets the baseball card collection and another month it's a different grandson, you can just keep changing your mind as long as you print out the list and date it and sign it. So that's a really good thing to be unambiguous about. We have had cases in this office that literally caused World War III over the soup tureen or the moose antlers. It just absolutely unbelievable that people would fight so hard about things of, fairly low monetary value, but very, very high emotional value. And so you can avoid that fighting by just saying, okay, this is who's going to get it. Some people will put a process in their will about drawing straws or picking items. I've found that most families can sort that part out on their own. But if there is a particular piece of jewelry, a ring, piece of art, a particular photo, something that more than one person is going to want, it's very, very helpful to have that tangible personal property list. One other thing I'm going to talk about, which is not technically part of estate planning, but has caused serious, serious problems for so many of our clients, is the family member who is the failure to launch. The family member who lives in the basement apartment for sometimes decades, and can cause problems when the person who owns the house needs to either move a professional caregiver in or sell the house and use the equity for care. Because sometimes the kids who live in the basement are not employable, have no income, have nowhere to go, and at the time when the elder really needs that house to be sold, they refuse to move and cause a lot of problems. So the first thing I would recommend is be very, very cautious before you allow a family member who has nowhere else to go to move into your house, because that can create a situation where you will feel very guilty if at some point 10 years down the road you have to say, I'm sorry, you can't live here anymore. But the next best option is to have a written rental agreement with that person. The rent can be minimal. The rent can be, $50 a month. But if you have a rental agreement and you are collecting rent, then landlord-tenant laws apply. And the agreement has to be very clear to say, this is my house, and there may come a point where I will give you 30 days notice and you have to leave within 30 days. And where you go will be your responsibility and not my responsibility to find you a place to go. Because this is oftentimes a very large asset, and possibly the only asset that someone has to pay for their own long-term care. And having that person who may have very few job opportunities living there is a huge problem. So I mentioned that in my discussions because it just has been really devastating for a lot of our clients. Now, I'm not talking about the the good kid who moves in specifically to be a caregiver. You know, those are really good situations. We like the kids that agree to help out in a good way, but they're also not the ones who refuse to leave. So I'm talking about the family members who are there for their own benefit and not for your benefit. And it can be very difficult to get them to leave after 10, or sometimes we've even seen 20 or 30 years of residency, and they just won't go anywhere. Another area of conflict involves how much you want to share about your estate planning documents with your family. Who you've chosen as your power of attorney is generally something that is going to be known among the family. If you have 3 kids who are all going to be fighting for control, they're going to know who is named as your power of attorney. So that's not something you can generally keep private. But that would be a situation that if the fighting is extreme, or if any of the family members are, you know, being too overbearing, taking over too much control, not listening to you and your wishes, that could be a situation where having a professional would be more in your best interest than having your kids fighting over who gets control. If you are, in terms of sharing the information that's in your will, there's generally no harm in that if it's what's expected, meaning that if you have 3 kids and you're leaving everything equally to your 3 kids or to their children if they predecease you, that's going to be expected, and nobody's going to be surprised to see that. If you are leaving an unequal distribution, or cutting someone out, or leaving a large gift to an organization that your family might not agree with you about, then you can keep that will private. You do not have to show it to anyone. And it's sometimes a good idea to keep it private, because if they know about something they don't like, they're going to be pressuring you to change it. So you absolutely have the right to keep your will private. It's a good idea to tell the person you've named as executor that they have been named and where they can find your original will, so that they can take over when they have to, but you don't have to share the contents of the will. I don't recommend the idea of, I leave my son John $1. The problem with that is, contrary to popular belief, it's perfectly valid to say, I leave my son John nothing. And by leaving the $1, we have sometimes had situations where perhaps John is estranged from the family and nobody knows where he is, and the executor has an obligation to spend thousands of dollars on a private investigator to find John and give him his $1. And so we don't think that's generally a good idea. It's perfectly fine to say, John gets nothing. I typically don't advise writing lengthy letters of explanation about that. I think that if you're cutting someone out, it's a really good idea to tell your attorney why you're doing that and have your attorney keep notes, but you don't really want to give that person a lot of ammunition to say that somehow you are mistaken in your facts. I'm leaving John nothing because he is a drug addict is kind of opening the door to John trying to prove that he never was a drug addict. So we don't generally do that. Okay. One of the questions, we're kind of switch gears now to advanced directives and POLST forms. An advanced directive, also called a living will, is a document that expresses your wishes for end-of-life care in the future if you are dying or in a permanent unconscious condition, or in the end stage of a very progressive disease where you can no longer speak for yourself. So future tense, if I am at end of life at some point in the future, then these are my choices about being on a ventilator, getting CPR, getting tube feeding, tube hydration. The POLST form is the lime green form that you get from your doctor. And POLST stands for Physician's Orders for Life-Sustaining Treatment. And this form is the right now form. It replaces what we used to call a do not resuscitate. So if at the point you're at in life, if because of your age or a life-limiting illness, you have said, if my heart stopped right now, I don't want CPR. That has to be in the POLST form. And the reason for that is that that is signed by your doctor. That's what makes it physician's orders. And the EMTs can follow that and will not provide CPR if they have a doctor's orders to the contrary. Similarly, you can say, I don't ever want to be transported to the hospital. I don't ever want, I don't want antibiotic treatment. So the POLST form is the right now form, and the advance directive is the future form. One of the questions I got in advance was new technologies in terms of treating someone at end of life. That's not something that is within my knowledge base, but there is a resource that I wanted to tell the folks about, because you might not know it exists. And there are professionals now, and you can do online searches for this, that call themselves end of life doulas. A doula is the word that is used in childbirth as the person who helps the mother, and an end of life doula or an end of life consultant is somebody who helps a family with end of life issues. And they're described as being somewhere between hospice and the caregiver. They help with a lot of additional services in terms of education and resources, facilitating end-of-life planning, mediation and advocacy with your family, healing unresolved loss and grief, lifting the burdens that the family's going through, creating a sacred space. And so this is a career that is fairly new. And so I thought I wanted people to know about the end-of-life doula, and you can go online and you can find people who are doing this. And then there are also a lot of times people have questions about, in terms of end-of-life care, about the death with dignity law, sometimes called physician aid in dying, where a physician prescribes a prescription that the person can self-administer to end their own life. The law is exceedingly clear that this has to be a choice by the individual, who has to be evaluated and certified by, I believe, 2 doctors as having the capacity to make that decision themselves. So this is not anything that you ever are able to put in a power of attorney saying, I authorize my agent to provide death with dignity for me. That is not the law, and it's never, I don't think it ever will be the law. But a lot of these specialists, whether it's a medical specialist in palliative care, whether it's an organization like End of Life Washington, or whether it's a death doula, an end of life doula, there are a lot of options available for managing end of life care. And I would encourage anybody who has questions about that or wants to make sure that they're in control, that you start with one of those organizations or individuals and research all of the options that are available. Another question that I got in advance was about the law that passed in Washington in May of this year that says that we now have options besides burial and cremation. And what is now legal in the state of Washington is something called alkaline hydrolysis, or aquamation. And what that means is a breakdown of your remains by water and non-toxic chemicals. So the result is similar to cremation in that your body is broken down, but it's non-toxic and is said to have very little environmental impact. And then the other is a version called natural organic reduction or recomposition. which is a process essentially like composting. So these options are now legal, and also something called green burial is legal. And green burial means that there have been biodegradable materials used so that you're buried in the ground, but ultimately the result will be recomposition with no barriers or concrete or steel or anything like that. So from a legal perspective, we know that the law says these options are legal. That's not the same as saying that they're either available or not cost prohibitive. So if you're interested in one of these options, I think that the best thing to do is to contact an organization like People's Memorial that is or will be a provider for these options, and they can tell you what it will cost, and they can tell you when it will be available, because there's equipment involved, there's waiting lists. Not everybody, the day the law passed doesn't mean that there are providers who are actually set up to do this. So I know that People's Memorial is very interested in the new processes and methods, and so when these are going to be available, they're going to be one of the first to know. And so that would be a really good organization to do your research with. What we have done with our clients who want to specify a preference for an environmentally sustainable disposition is we have a little statement that says, it is my intent to have my remains disposed of in the most environmentally sensitive method available at the time. And then they let their designated agent decide if it is available or economically unfeasible, and then maybe express what your second choice is, that if that's not available, then I want burial or I want cremation. So we have ways of kind of leaving it up in the air because we don't really know what all is going to be available at the time. Couple of questions that have been posted. Can the fiduciary, i.e. power of attorney, be performed by a foreign national? I believe that is true for a power of attorney. It may not be true for a personal representative of your will. And again, the convenience is going to be important. Can that person, successfully fulfill the role? If it's your son who lives in Vancouver, Washington, the likelihood is going to be that there's no inconvenience there. But I do believe that they can for a power of attorney, but not as personal representative. A question of ways to get help thinking about how to select beneficiaries outside the family. That's a tough call because that's your choice. And what sometimes we try and tell people to keep their list reasonable, that if you think when you die you're going to have $25,000, don't name a list of 20 people to benefit from that. Be reasonable in relationship to what your assets are. But really that's a personal choice, and you have to decide, what do I want my legacy to be? Are there counselors or personal coaches who are capable and knowledgeable in both psychology and financial planning? I don't know. That's a really good question, and I don't know any, but that would be a really good thing to research. I think at this point there are some other questions, and I'm hoping that we're going to be able to get to all of those. But I'm going to toss it to Don now, and he's going to talk to you a little bit about his own experiences.
Thank you for this great presentation. You answered one of my questions. I had been thinking as you began your talk, gosh, I designated my stepson, or one of my stepsons, as my first alternate agent when he was living in Seattle, and then he moved to Vermont. And all this time I've been going, gosh, I'm going to have to make a change and do all this. Not really. You assuaged our concerns about having to have somebody physically in the state in order to be handling some of these responsibilities, because in this modern day and age, we just don't need that. So that was very much appreciated. So I am Don DeSonia. I'm the board president of NEST, Northeast Seattle Together. And I am going to chat for just a few minutes about legacy giving. And Janet had mentioned towards the end of her presentation that as you're making choices and decisions about who your beneficiary is going to be in your will or other, estate planning dispositive document, it's your choice. You make a decision based on how you want to devote or give away your assets. It's your legacy. It's what you want to do. So just by way of background, I was married to my wife, Nancy, for 24 years. And in January of 2008, she was diagnosed with early onset dementia. And she had just turned at the time 65. Over time, Nancy's dementia progressed to a point where in July of 2010, I came to the realization, which was very difficult, one of the most difficult decisions I've made, that her needs would best be served by moving her to a memory care residence in Washington State. And when Janet talked about powers of attorney, I can't emphasize enough how important they are. Durable powers of attorney for financial decisions and healthcare, which, as Janet mentioned, can be two separate documents or all one document. I had both of those, and they were my golden ticket to the decisions and choices I had to make throughout Nancy's dementia. So that's a really important piece of your estate planning to pay attention to. So in July of 2010, Nancy was moved to a memory care residence. And in July of 2012, July 4th, as a matter of fact, Nancy passed away. And in the last roughly 2.5 years of Nancy's life, she was fully cared for from a healthcare perspective by Evergreen Health Hospice. I made a decision in the spring of that year that it was time to engage hospice, and I did that. And I chose Evergreen because it was felt by me that of all the options I had, they were the most competent, most gracious, most compassionate. They're all, I'm sure, fine, but that was just one that I made a choice over. And indeed, the professionals at Evergreen Health Hospice were sensitive and empathic and truly just amazing. I was overwhelmed by their care and compassion and the quick steps they took to make Nancy's life easier once they came on board to provide for her care. And my own needs, my own concerns and questions I had as I was becoming aware that I was nearing the end of my caregiving journey with her. She passed away, as I mentioned, and several years later, as I was looking at my own estate planning and the choices and decisions I wanted to make, I decided I want to honor her and support Evergreen Health Foundation hospice care, through which she had received such loving care and attention. In short, I wanted to leave a legacy. And so I decided to revise my then existing estate planning to include Evergreen Health Foundation, an IRS registered 501c3 nonprofit, in the allocation of my tax deferred investment account, which is a SEP IRA. So that was several years ago. I've since updated that designation, and in conjunction with that, in fact, I updated it to make it open to have the portion of the SEP IRA going to Evergreen Health Foundation to be at the area of greatest need. At the same time, I decided I wanted to add on to my designation through my legacy giving NEST, Northeast Seattle Together, of which I just mentioned I'm the board president. NEST now has a legacy giving program. One can make a decision to designate Nest as a beneficiary of your assets through a legacy giving process in your will or estate planning. So I further revised my tax deferred investment allocation of my IRA to include Nest in that process, because I wanted to make sure that the two organizations that are really very near and dear to my heart will someday receive a benefit for the amazing and compassionate work that they do. So as you're looking at your legacy, as you're deciding your estate planning and incorporating all the things that Janet has talked about, and we're blessed in the state of Washington with having a very straightforward and simple, probate process. As you're considering what to do, give some thought to an organization that you feel very strongly about, that you feel very akin to and in sync with, and you want to benefit them by designating a gift through your estate plan. And if you're doing it to a nonprofit, the one thing that's important to know, and I'll preface this by saying, consult your tax advisor. Your legacy gift can be tax-free. My SEP, for example, is with Charles Schwab, and I arranged through Charles Schwab to have the portions of that SEP divided between Nest and Evergreen Health Foundation within Schwab, so they know what my wishes are. And so that way, it becomes a tax-deferred gift to Nest and to Evergreen Health Foundation at my passing, and my estate is not taxed because the SEP remains within its tax-deferred bubble, and the money is distributed within that bubble to a nonprofit, and so it's tax-free all the way around. So that's pretty much it. That is my little comments and observations on legacy giving. It's a wonderful way to benefit a nonprofit, as an example, that you feel very strongly about, that you care about, and you want to honor that. And maybe it's a loved one that you're honoring, like I did with my wife, Nancy. So that is what I have. And I believe, Janet and Chris, if I'm not mistaken, we are now at the Q&A stage, and you started to answer some questions, and I'll turn it back to Janet to continue with that process.
Yeah, and I want to make sure that everybody has the opportunity to ask a question. We don't want to leave out the folks who are on the phone only. So is there a way for the phone folks to indicate if they have a question
they can just speak up. Just speak up.
I believe right now they're muted right now. And
yeah, unmute yourself. Unmuted.
You need to unmute. I'm asking them to unmute.
Okay, well, while we're waiting for people to think of their questions, there are a couple more that have been typed in. And one of those is, what do you do about a pulse if you don't have a personal physician? Well, this is a form that can be signed by any physician or a nurse practitioner. Registered nurse practitioners can do just about anything in Washington that an MD can do. So I believe that you could make an appointment with, even perhaps one of the walk-in clinics to see a nurse practitioner, and, make sure that I would call in advance to make sure that they have the forms available, because that wouldn't be something that they maybe get questioned about every day. But any physician or nurse practitioner would be able to sign that form to make it a valid form for you. Okay, there's a question about using Willmaker software, and on that one I have to say I'm a biased source. I do this for a living, and I believe that there's good value in working with an attorney to prepare your estate planning documents. That being said, our prices to do that might be more than what some people are able to pay. If you are low income, there are some basic estate planning services provided through the legal clinics that are in King County, run through Sound Generations, which is the name that used to be Senior Information and Assistance. So if you contact Sound Generations and ask for their legal clinics, they may be able to provide some low income help in that regard. I would also say you can call around and research what attorneys charge, but because some will obviously charge more than others, and you can research for costs that way. We have seen problems with software that people filled out on their own, and the main problem is you don't know what you don't know. And so the software can only be designed to answer so many questions. And if you don't think of the right question, you're not going to, you may end up with a document that doesn't actually do what you want it to do. And so it's, you know, if I have a plumbing problem, I want to hire somebody who is a qualified plumber and not have my husband do it, because that creates problems. So my bias is I think that estate planning attorneys will help you get the documents that are right for you. But if you have a very simple situation and LegalZoom or one of the other services, you think that's going to be all that you need, just make sure that you absolutely follow all of the instructions and get it witnessed and notarized exactly as they tell you to do it.
We do have a hand raised from Leah.
Okay, Leah?
I was starting to type in the question, but my assets consist of my house, which has a mortgage, and a modest investment portfolio at Merrill Lynch. The portfolio has automatic transfer of ownership to my 2 children at my death, and the house has the same. Will those then be tax-free?
Okay, that's a really good question, because people are often very, very confused about what's taxable and what's not taxable at death. The tax that applies to the vast majority of my clients is really limited to the income tax that might have to get paid on a 401k or an IRA account where you've never paid the income tax. When you withdraw money, you pay income tax on it. If one of your heirs inherits that account, then they have to pay the income tax when they pull the money out. But the estate tax in the state of Washington is exempts the first $2.2 million of your estate. So no estate tax will be paid if your estate is valued at less than $2.2 million per spouse. And you know, if you're a married couple and you have $4 million, then your attorney can explain to you how we work that to make sure that you each get your $2.2 million exemption. So there's no estate tax for inheriting the house or the brokerage account if the total there is under $2.2 million. And I will also give the qualification. I am not a tax expert. I have a tax attorney down the hall from me, so I run and ask for questions that are beyond my scope, but I know enough of the basics. So I know that that's the rules with estate tax, and you don't ever get to avoid paying the tax on an IRA or a 401k. Eventually someone will pay income tax when that money is withdrawn. And then the other nifty tax rule has to do with capital gains tax. Now, if someone inherits property from you, so sometimes people will say, I have a house and I know I want my daughter to have it. Why don't I just transfer it to her now while I'm alive? And the reason for that is if you bought that house in 1975 for $40,000, and you transfer it to her during her lifetime, that will be her basis, her starting point. And when she sells that house, she'll have to pay capital gains on the difference between 40,000 and whatever it's worth. If she inherits that house from you, she gets what's called a step up in basis, and her starting point is the date of death value. So nobody pays that capital gains tax if that house is inherited. So that's another nifty thing. So taxes at death are something that people are often overly concerned about, but are treated fairly well for the consumer in probate.
Thank you.
Do we have any other hands up?
I noticed, Janet, that there's a question, what are some vetted services that might be useful for organizing and putting a household in order? And I'm going to take a wild guess that this question is based on, and the questioner can follow up or if they or talk to us if I'm not interpreting this correctly, is getting your house in a space where you know where your assets are, you've organized it, maybe you're moving or you're getting ready to transition in your life. Are there organizations that can help organize your stuff?
Oh,
I'm guessing that's the question. And there's many. And I used one when I moved from Mercer Island. A few years after Nancy died, I decided it was time to move on and get into my own place. And so we had lived in that house for 30 years, or I lived in it for 30 years with her. And so there was a lot of stuff. And so I spent a good year downsizing, and I engaged a company near the end to help me with the remaining stuff. So there is organizations that can help with that transition and can help you look at what your priorities are. As my real estate agent said to me as I was doing all this last minute stuff, Dawn, don't forget, if you don't give it away, sell it, donate it, or list it on Craigslist, you're taking it with you. So I took that to heart. And that involved many visits with my stepkids, Nancy's children, to do their own vetting and what they wanted to keep or take. And that's another thing, interestingly enough, I just thought of this. As we think about, Janet, estate planning and what you're going to give and all that, and you're moving or you're doing this and that, getting your children involved in what do you want to need? We're talking about not the house transfer thing that you talked about, but mementos and assets and things and stuff, and having them have a say in that. And yes, you can make the list that you described, Janet, which is very handy. You can change it a million times, or you can have this, and unfortunately it took my wife's passing to have that process undertaken, but it was revealing, it was enlightening, it was an opportunity to get together with them and look at old photographs and stuff and rings. I mean, there was elements of silver linings to all of that, but it was a good way to help with my downsizing.
And I would also say it's really good to have that conversation about what the kids don't want, because the women of my mother's generation who were so proud of their china and their silver and their crystal, and carefully preserved it to pass down, are now finding that a lot of times the younger generation isn't interested, that they don't have those kinds of big dinners. They don't want to worry about breaking the china, and that mom saved all of that very carefully, and now it turns out that they really
Well, that's exactly right. I had both my wife's mother's sterling silver and hers. It's not a big ticket item with the younger generation.
Right.
Nobody wants that. Nobody wants that. Nobody wants silverware where when you put it out for a fancy dinner, you got to hand clean it all. I mean, who wants to do that anymore? So
Okay.
it's a whole different.
Do we have other hands raised?
Francine,
Yes.
All right.
Yes. Regarding the advanced directive living will and the physician order form, do you recommend both? And two, does one supersede the other?
I do recommend both because they really have different purposes.
Yes.
The advanced directive is only effective in the future at the point where you are at end of life or permanently unconscious. So that's not going to cover all situations. And so one doesn't well, the POLST does supersede the advanced directive in the fact that it's present. So if your pulse says no CPR, then that's going to control if your heart stops, because that's the right here and now. Now, not everybody needs to have a pulse right now. If you're at a point in your life where you want all medical interventions, if you were to suddenly be in an accident or have your heart stop, then you don't need a pulse. The doctors say that a pulse is intended for people who, either because of their age or a life-limiting illness, it would not be surprising to their medical providers if they were to die of natural causes in the next year. So that kind of narrows it down. So if you have a diagnosis of cancer or Parkinson's or something like that, then it's appropriate to have a pulse so that your family and your doctors know exactly what you want if you should go into crisis. Even if you're 98 and you still are, going out and walking 3 times around Green Lake every day and chairing 14 boards, you might not need a pulse because you'd still want them to do everything possible to get you back to your good health. So the pulse form is for someone who basically wants less than full intervention. If you know you don't want CPR ever, you don't want a ventilator ever, then it would be appropriate to put that in a pulse form. I'm going to address one of the questions that's in writing, and it's kind of a 2-part question. It's how do you get your estate planning documents done under short-term pressure and also under the threat of COVID-19? So the first part of that I'm going to answer is how we're doing documents for people given the current shutdown restrictions. And I think that most attorneys have adopted fairly similar practices. The way we're doing that is we do everything virtually until we have to have the documents signed. And so we do an initial appointment virtually. Our preference is to do it by a Zoom video chat because then we can see who we're dealing with. But if that's not possible, then we do it over the phone. And we have a questionnaire that is on our website. It's free for anybody to download. It just kind of walks you through what choices, what information we need to talk about at that first information, what assets you have, what questions you have, and who you want to pick for the different roles, and what you want to do with your assets. That questionnaire is available, and we get that and go over that together at the first virtual appointment. We then draft documents, we send them to the client for review. If the client has questions at that point, I don't understand this paragraph or that paragraph, or I don't know why you did this, then we schedule another virtual appointment by phone or by Zoom to answer all of those questions. When the documents are ready to be signed, preferably we have the clients come into our Northgate office for what usually ends up being about a 20-minute appointment. We only have a skeleton crew working here, separate from each other. We all wear masks. We have plexiglass sneeze guards in the reception area in the conference room. We ask the clients to wear masks and not come if you're sick, et cetera, et cetera. And we get you in, sign all the documents, notarize, witness, give you your originals, and send you back out and get you out of here in about 20 minutes. So it's about the same level of risk as going to a doctor's appointment. And we keep everything as scrubbed as possible, and we've had no problems with that. On occasion, one of our attorneys will go and make a house call. There are attorneys who currently will make house calls to hospitals. Our firm has made the decision that that's too great a risk for our staff. So we're not going to come see anyone in the hospital. And if we're going to come see you in an assisted living community or in your home, we're going to evaluate that on a case-by-case basis. And we have made house calls to a client's home or to, usually the assisted living can set aside a clean conference area, or even I went to an adult family home where we sat outside at the picnic table and signed documents. So we evaluate all of that on a case-by-case basis. But the easiest thing for us and the cheapest for the clients is to come here for the 20-minute appointment. Now, the other part of the question was how to get it done really quickly under pressure. And I would say, again, you might be calling around to a number of attorneys. Most attorneys are booked out, you know, not a huge amount, but maybe 2 to 3 weeks in advance. And so we're often heartbroken when we get a call from someone that says, my dad's in the hospital, he's dying, he really needs to update his will, can you help us? Very frankly, the answer to that often is no, we don't have anyone available to either go to the hospital or to help with that. And sometimes dad no longer has capacity because it's too late. So the message there is we can do documents relatively quickly if you are, you know, have a scheduled surgery coming up and, you know, you've got 3 weeks before your hip surgery and you really want to get this done. But we really don't like getting those calls saying, I need it tomorrow. And we often have to refer those out to try and find someone else because we're generally not able to drop everything for someone who's never been a client of ours before and risk our own health to help with that. So that's our process. We think that we do a really good job of keeping everybody safe. The law is archaic. I mean, there's no DocuSign. Right now, there's no virtual way to sign your estate planning documents. You have to, for the powers of attorney and the advance directive, the powers of attorney have to be signed in front of a notary. The advance directive can be signed in front of a notary or with 2 witnesses. The will has to be signed in front of 2 witnesses. There's no way around that. And so we do our best to make that as safe as possible.
Question from Leah.
Yes, this is really asking you about your experience in relation to this. As I say, my portfolio is modest and it changes as the market changes, which is a pain in the neck. And I have left it equally between my 2 children. Each of my 2 children has 2 children. Mm-hmm. My theory was I'll take care of my children and they'll take care of their children. Mm-hmm. Now, when my mother died, she left, I think, half of her financial estate divided between me and my sister, and half of it divided up among her grandchildren. And it was, again, not a lot of money, you know, $90,000 to me and $40,000 to each of the grandchildren. And in your experience, what is the better way to do that? I mean, when we're not talking about large sums of money that, you know, you can say, oh, I leave 25,000 million to my grandchildren and 100 million to my kids, you know, just.
Yeah, I would say, I can't say what's best because it is clearly a personal choice. You can do it any way you like. I would say what is most common is that most people do what you have described, which is I leave it equally to my children. Now, if one of your children were to die before you, then that share typically goes to their children split equally. That's either called, the Latin version of that is per stirpes, and the English version is called to my descendants by right of representation. But that's more typical,
Oh, typical, yeah.
other than I think people with larger estates might leave, not large amounts to grandchildren, but they might say $10,000 to each of my grandchildren, so there's a little something they can use right away, or specify some amounts to go into a trust to make sure that if one grandchild's college has been paid for, that the others will get paid for, that type of thing. But I would say it's much more common for parents to leave everything to the next generation and let that generation worry about their children.
That's what I thought. Thank you.
Janet, I received a question via email.
Mhm.
And I didn't get a chance to send that out to you in time, but the question is, this particular person has a simple will with his son as an administrator.
Uh-huh.
He has less than 1 million in assets. He owns a house free and clear. He also owns a commercial building with a tenant and a mortgage.
Mhm.
So when he passes, can his son sell the house without going through probate? And if not, what can be done?
Okay. The real estate is usually the deciding factor as to whether or not probate is necessary. And what I would say there is the commercial building is also a factor, that the title to both of those pieces of real estate are going to have to get transferred, even if he wants to keep the commercial building, and that would require probate. But as I said earlier, probate in Washington is no big deal. We don't go to a lot of effort to avoid probate just to avoid probate. One of the factors is financial institutions are very, very comfortable with working with personal representatives who have what's called letters testamentary, which is what you get when you open a probate. And sometimes when property is in a trust or other methods have been used to try and avoid probate at all costs, you end up spending far more hours sitting in the financial institution than you would have if you just walked in with letters testamentary. So we're not foes of probate. And again, the attorney can walk him through everything he needs to do. But having the commercial property, there's basically two pieces of real estate, and both of those are going to need to be dealt with, and a probate would be necessary.
Great. I'm sending this recording to him, so I'll let him know when that
Okay.
his question.
I see a question on here about a 26-year-old will, which was a joint will at the time the husband died. I will say that we don't see a lot of joint wills in Washington. And there are a lot of kind of tricky legal issues as to whether it's a joint will, meaning that both of your names are on it, or whether it's somehow something called a mutual will or a contract to make a will that would mean once your husband has passed away, you can't change it. It would be something that an attorney would have to take a look at to make sure that you had the ability to update it after your husband's death. If you don't need to update it, if it's still appropriate to give everything to your children, then if it was valid when it was signed, it's going to be valid now. Wills don't expire. And a will, there's if we remember the part of the Constitution that says full faith and credit, the full faith and credit clause means that a legal document, including all estate planning documents, if it was valid in the state where it was created, it is valid in any of the other 50 states. So that's often a question we get. Similar to Don's question about, can my executor be out of state? If you have a will from another state, it is valid in Washington. Because sometimes you don't have the option of updating it.
All right, are there any other questions for Janet? Okay, I don't see any other hand raised. All right. Last call.
I see something in my notes that is sometimes a question that comes up, and I'm gonna toss it out just because I forgot to mention it. And that is, where do I keep my original documents?
Oh, good.
The law, like I said, is archaic, and original documents still matter for your will and your original power of attorney for finances. So it's a really, really good idea not to lose them. And so we do not recommend putting them in safe deposit boxes, because that is a classic Murphy's Law, that if you put it in your safe deposit box, then you're not going to be able to get at it when you need it. And it's very, very cumbersome to get someone's will out of a safe deposit box after the person who wrote the will has died. It's just you can do it, but it costs you. So we don't really like safe deposit boxes for original estate planning documents. Pick a place that is safe in your home. It might be a firebox, it might be a filing cabinet, it might be a notebook on a shelf. It's okay to 3-hole punch your documents and put them in a notebook. Pick a safe place and tell someone else where you put them. And just, documents are rarely stolen or destroyed in a fire. They are frequently misplaced. So that's your goal, is to not misplace your original estate planning documents.
All right. Anything else from anyone? No? Oh, question from Francine, looks like.
The question is why does real estate decide whether somebody goes through probate?
Because there are other good options for everything else. If you don't own real estate and all you have are financial accounts, then you can name beneficiaries for those accounts, and those will pass out of probate, and there won't be any necessity to do a probate. I will say that there is a process called a transfer on death deed. That is a process where you can leave a piece of property to a beneficiary. I don't often recommend it, because if the property is going to be sold anyway, it's generally easier to do that through a probate than to transfer the property and then have the beneficiary just have to turn around and sell it. It's just extra steps. So yeah, so there are very few good options for real estate. Also, the transfer on death deed is not appropriate really if that property is going to go to more than one person, because then, you know, your 3 kids who live in 3 different states now own a house together and they don't have any way to manage it together. Again, if it's sold in probate and the proceeds are distributed, that's a lot. We always emphasize what's the simplest and most efficient way to proceed. That's you know, so we don't look at is probate needed or not. We look at what's the best way to proceed, what's the simplest way to proceed.
Okay, thank you.
Right. Any other questions? All right, just one last, a few comments from me. I just want to thank everyone for attending. I especially like to thank Janet Smith for this wonderful presentation. Thank you so much. And also from our board chair, Dawn DeSaulnier. Just so you know, Nest also has, you know, each month we have programs that are free and open to the public. We hope to do more of these. Of course, as we know, they will be over the Zoom platform, and that's what we are using for the time being. We hope to see people in person sometime soon in the future. But with that said, I thank everyone for attending. Please stay safe and healthy and enjoy the rest of the sunny day. Thank you.
No, just one last comment, not a question, a comment. This is Lori, and during Janet's presentation, I got cut off. Well, and then I got the recording. If you wish to make a phone call, hang up and call. So I did, but I don't know why it happened. I don't know if there's something that could have prevented it.
Thanks for letting us know. Yeah, we'll look into that and we'll see what happened. I don't know. I didn't get a.
Okay, and I can tell you the time it happened. if
We
that
can
does
we
you
can
any
talk
good.
offline about that. We'll talk offline about
Okay.
that. Thank you.
Thank you.
All right, thank you.
All right. Thank you, everyone.
Thank you,
Thank
Janet.
you.
Thank you, Jess.
Bye-bye.
Very helpful.
Bye.